Is inheritance tax the biggest threat to the legacy I leave my children? Or is it divorce, bankruptcy, care costs, or other unwanted claimants I haven't even thought about yet? For many families, it's not just one of these, it's all of them. And the biggest risk of all, doing nothing. Estate planning isn't just about money, it's about protecting your family, your values, and your wishes. But here's the harsh truth: money can change people. People you trusted can behave very differently when inheritance is involved. Families fall out, people take sides, and when there's no plan, or a bad one, it can bring out the absolute worst in people. I know this because I've lived through it. My grandmother was left destitute despite my grandfather putting things in place. Her story was featured on ITV's Tonight programme twice.
Good evening and welcome to the Tonight programme. It's one of the cruelest crimes, being conned out of your hard-earned cash. But what if it's someone you know and trust?
You can watch some of it on our website, and I've linked it in the video notes below. It's not easy for me to talk about, but I share it because so many others have lived through similar things. People reached out to me after the programme aired, and the stories were just heartbreaking. The golden rule of estate planning: don't wait. A solid estate plan needs to be made early before it's too late. It also needs to be flexible. Life changes, families change, your plan should also be able to change with it. And crucially, it needs to be secure, kept somewhere your executors or attorneys can find. If a will goes missing or it's destroyed, even by someone with bad intentions, the law assumes you destroyed it yourself. That's exactly what happened in our family. And when that happens, you're looking at months of legal disputes with little or no guarantee of success. My grandfather was sharp, a director at a large company. He'd worked hard, planned ahead, set up wills and LPAs through a solicitor he trusted. He did everything he thought was right. When he died, my grandmother had her care fully funded. Pensions alone covered the costs. She was comfortable, but by the time she passed away, she had nothing at all. After she died, the solicitor who had drafted the will had retired, and the firm he sold to stepped away from their executor role. That made it incredibly hard to get anywhere. If it weren't for my mother's meticulous records, we'd have been lost. That solicitor had faced pressure and abuse from my Uncle Richard as he pushed to become attorney. Richard was eventually prosecuted and jailed for 5 years after the care home reported him to adult services. A few years later, he was taken back to court and ordered to repay what he had stole or go back to prison. He chose to run, and to this day the police still haven't found him. That's why this matters. It's not just about having a will, it's about having the right plan. I sometimes joke, slightly tongue-in-cheek, don't leave anything to anyone. Of course, I don't mean that literally. What I mean is, don't just leave things outright without thinking it through. Consider the use of trust to protect what you're passing on. One of the strongest ways to future-proof your estate plan is by using professional executors and professional trustees. Yes, there's additional cost, but in return you get dedicated professionals whose sole role is to carry out your wishes properly, fairly, and with legal accountability. Professional trustees act as gatekeepers. They hold the trust assets legally, and they're duty-bound to manage and protect those assets for the benefit of your chosen beneficiaries. They're neutral, process-driven and experienced, which can be invaluable if there's complexity, risk of family tension, or substantial value involved. Of course, you can absolutely involve family too. In fact, many people choose a combination, for example, appointing one family member alongside a professional, blending personal insight with independent oversight. And if your family members are capable and confident, they can absolutely act alone. It's about what's right for you and your circumstances. Managing a trust isn't overly complex. It's no more difficult than handling the finances of a small business, which I'll cover in a separate video. A good estate planner won't just hand you a template will. They'll ask you about your family dynamics, your worries, your goals, and tailor the solution to fit. For small or straightforward estates, a basic will might be enough. But if your estate is larger, your family setup is more complex, or there are sensitive issues like special needs or potential conflict, then a trust-based plan can offer far greater protection and control. The biggest mistake is not having a will at all. If you die without one, your estate is distributed according to intestacy rules, rules which are antiquated, rigid and completely disconnected from how families actually work today. The outcome? Well, family disputes, lost inheritance tax allowances, and your assets potentially ending up with people you never intended to benefit. A deed of variation can sometimes be used to make changes after death, but it puts the control in someone else's hands, not yours. And it can easily create unintended tax problems, particularly for married couples. Joint assets pass automatically to the surviving joint owner, but that can come at a cost. If your joint owner is your spouse, the asset bypasses your will entirely and goes straight into their estate. Now that might seem harmless, but it means you won't use any inheritance tax allowances on first death. While the nil rate band NRB and the resident nil rate band RNRB are technically transferable to a surviving spouse, this isn't always ideal in practice. For example, if the survivor's estate exceeds £2 million at the time of their death, the RNRB starts to taper away and can be lost entirely. And if the government changes the rules, scrapping or reducing the NRB or RNRB in future, those allowances may no longer be available to claim at all. In many cases, using the allowances on first death secures them, locking in tax savings while they're still available. If the joint owner is not your spouse, such as an adult child, the situation can be even worse. The asset won't qualify for spousal exemption, potentially triggering an immediate inheritance tax charge. And regardless of who the joint owner is, that asset now forms part of their estate and is exposed to risks like care costs, divorce, bankruptcy or remarriage. So while joint ownership may seem simple and efficient, it can undermine your estate plan if it hasn't been carefully considered. When thinking about your will, it's worth stepping back and asking some practical questions. Do any of your children have special needs or disabilities? Would they be able to manage a lump sum, or could it impact any means-tested benefits they rely on? Are they vulnerable to outside influence or at risk of making poor decisions? What if your spouse were to remarry? Could that redirect assets away from your children? If your spouse needs care in the future, would your whole estate be at risk, or just their half? What about your children? What if they needed care themselves, went through a divorce or had financial troubles? Could the inheritance you leave them actually create inheritance tax problems in their own estates? And are they financially sensible, or do you worry the money might be spent too quickly? These are real world issues, things that come up all the time in families, not just hypotheticals. A good estate plan doesn't just divide up assets, it anticipates situations like these and puts safeguards in place where needed. These considerations are also applicable when grandparents are thinking about how to bequeath assets. We've talked a lot about what happens when you die, but what if you're still alive, just no longer able to act? That's where lasting powers of attorney come in. There are two types. The first type is property and financial affairs for your money, property and bills, and the second type is health and welfare for medical decisions, care preferences, even life-sustaining treatment. Without these, even joint accounts can be frozen. Your spouse might not be able to act for you. It could fall to the court of protection, which is slow, costly and stressful. Choose your attorneys wisely. Trust is key. In my grandmother's case, it was my uncle, and he used his role to take everything. If you have any doubts, consider appointing a professional attorney for property and finances. Someone neutral, accountable and conflict-free. And let your attorneys know what's important to you. For instance, regular gifts, care preferences, family values. Speak to them, involve them. Don't leave it to chance. Where you can, be open with your family. You don't have to go into every detail, but if you're planning to leave assets in trust, restrict assets, or structure things in a certain way, it helps to explain why. Other people are left guessing, and in the absence of answers, assumptions can take over, which can lead to resentment, conflict, or even legal challenge. A simple letter of wishes or even a short video message can go a long way. It doesn't need to be formal or emotional, just honest. Tell your beneficiaries what you've done and, more importantly, why you've done it. Your voice, your actual words can be powerful after you're gone. It can bring comfort, offer clarity and help prevent disputes before they even begin. It might feel uncomfortable now, but it's one of the most valuable things you can leave behind. Your estate isn't just your money, it's everything you leave behind, not just the financial but the personal. The stories, the memories, the values, the little things that made you. Maybe it's a favourite recipe you've always made for Sunday lunch, or a handwritten letter of advice for your children or grandchildren. A story from your childhood they never got to hear. These are all the things that people really hold on to. They might not have a cash value, but they carry far more weight. This is your opportunity to leave behind something truly meaningful. Something your family will treasure, not just for what it says, but because it came from you. Don't overlook your digital assets. These days, some of the most important things we own aren't physical, they're digital. That might include family photos stored in the cloud, important documents in your email, social media accounts, subscription services, or even crypto wallets and online investments. If no one knows these exist or how to access them, they can be lost forever. Make a record of what you have. Think about using a password manager and make sure someone you trust knows where to find your instructions. Whether it's sentimental or financial, your digital legacy is part of your estate and it deserves just as much thought as your property, money and possessions. Estate planning isn't just a legal task. It's about taking care of the people you love when you're no longer here to do it yourself. And like most important things in life, the earlier you start, the more options you have. Build a plan that's flexible so it can evolve with you. Store it safely, somewhere secure, where it can't be lost, damaged or tampered with, and where the right people can find it when the time comes. Talk to your family so they're not just left with confusion or tension. And most importantly, make sure your plan protects more than just your money. It should protect your people, your values and your intentions. Look at where you can simplify things. Consolidate accounts if they're all over the place. Keep a record of the gifts that you've made. And if you've got strong feelings about how you want your funeral handled, say so. Write it down. Don't leave people guessing. Perhaps even consider a funeral plan. The best estate plans aren't just tax efficient, they're emotionally efficient. They make things easier for the people you leave behind at the hardest possible time. If anything you've heard in this video has struck a chord and you would like to understand how to apply it to your own situation, feel free to get in touch. Thank you for watching. Remember to hit subscribe for more useful content coming soon.